The stone had been sitting at the edge of Harlow's bottom field for 91 years. It weighed perhaps 14 pounds. It was limestone, roughly cut, the kind of marker a surveyor would have driven into the ground with a wooden mallet and a sense of permanent finality. The lettering on it read, "Property Boundary." 1898, and the chisel work was uneven, as if the man who carved it had been working in bad light, or perhaps in a hurry. Nobody had touched it in decades. Brambles had grown up around its base and died back and grown up again, season after season, until the stone was more monument than marker. A thing you walked past without seeing, the way you stopped noticing a crack in a familiar wall. Gerald Ashworth paid £460,000 for the land it sat on in the spring of 2009, and he never once looked down at it. That is where this story begins. Not with the legal battle, not with the drilling rig that showed up 14 months later, not with the courtroom in Exeter where a judge read a 47-word clause aloud to a gallery of stunned solicitors. It begins with a stone that everyone dismissed and one man who didn't. I want you to pay attention to that stone, because everything, every pound, every acre, every year of this fight comes back to it. Now, before I tell you what was written in that 1890 deed, I need to take you somewhere else first. I need to take you back further than 2009, further than the stone. I need to take you to November of 1890, to a farmhouse kitchen in the South Hams district of Devon, England, where a wool merchant named Everett Stokes was signing his name to a document that he expected to think about never again. Stokes was leaving England for Canada. He was 51 years old, recently widowed, and had no sons to inherit his affairs. The 43 acres he was selling, an undulating parcel of clay-heavy farmland that the locals called Harlow's Bottom, partly because of the shallow depression at its eastern edge, and partly because of a tradition of blunt Devon place names that went back several centuries. Had been in his family for 2 generations, but had never produced much beyond adequate grazing and a reasonable hay yield in a good year. He needed the money for his passage. The buyer, a farmer named Thomas Calloway, was prepared to pay £82 without negotiation, which in November of 1890 was a reasonable price for 43 acres of second-quality South Devon farmland. The transaction should have been unremarkable. But Stokes had a solicitor named Aldous Vickers. Vickers was what people in that era called a careful man, which meant a man who had once been surprised by something he hadn't read and had never intended to be surprised again. He had spent 3 years in the South Wales coal fields before moving his practice to Devon, and he had watched enough land disputes in that time to understand something that most agricultural solicitors in 1890 did not think much about. What lay beneath a field was sometimes worth more than what grew on top of it. He had seen men sell surface rights and watched someone else extract the mineral wealth below. He had seen families lose fortunes to clauses they hadn't noticed in deeds they hadn't read carefully. He was not going to let that happen to his clients. So when Vickers drafted the transfer deed for Stokes, he added something, 7 lines of Victorian legalese buried in the 3rd page, which established that the subsurface mineral rights to all seams, strata, beds and formations lying at any depth below 18 inches from the surface of the property, therein described, should remain vested in the vendor's assignees and their lineal descendants, and should not be conveyed by any subsequent transfer of the surface freehold without a separate and explicit instrument of conveyance referencing this clause by date and registration number. Vickers probably added it out of habit as much as foresight, the way a careful craftsman double-checks a joint that doesn't strictly need checking, because that is simply how he works. He couldn't have known what was under that field. Nobody in Devon was thinking about what was under that field in 1890. The science that would eventually tell them wasn't invented yet. But that discovery was 117 years away. And I'll get to it. First, let me tell you about a man named Robert Calloway. Robert was Thomas Calloway's great-great-grandson. He was 53 years old in 2009, a quiet man with large hands that had been cracked and reddened since his late teens from the particular combination of cold water, baler twine, and engine grease that defines farm work in the English southwest. He had a habit, which his wife Margaret had noticed early in their marriage and come to find oddly reassuring, of looking at whatever ground he happened to be standing on. Not as a romantic gesture, not the way a poet looks at the earth, but as a professional reflex, the same unconscious assessment a mechanic makes when he glances at the undercarriage of every car he passes in a car park. Robert looked at ground the way other people look at weather, constantly, automatically, reading what it had to tell him. He had farmed Harlow's Bottom his entire working life. Before him, his father Raymond had farmed it, and before Raymond, his grandfather Jack, and before Jack, great-grandfather William, and before William, Thomas himself, who had paid £82 for it in November 1890 and worked it until he was too old to hold a fork. 5 generations. 119 years. In Devon that counts for something, not in a sentimental way, but in a practical one. 5 generations of the same family reading the same soil produces a kind of knowledge that no agricultural college teaches, an intimacy with the specific drainage characteristics of a particular clay, the way the east corner floods before the rest in a wet February, the precise time in early April when the ground becomes workable. Robert knew Harlow's Bottom the way he knew the layout of his own house in the dark. He ran 60 Hereford cattle on the land, a mixed herd that he'd built from 42 animals over 12 years, and he leased the east parcel, 14 of the 43 acres, the flatter ground that worked for arable, to a neighbouring operation run by a family named Trevithick for £17,000 a year. It wasn't a prosperous farm by any modern standard. It was a working farm, which is a different thing. It paid its costs and fed its family and put modest sums aside, and in good years it did a little better than that. Then came 2008. Now here is something you need to understand, because the financial crash of late 2008 isn't just background to this story. It's the mechanism by which a man in Bristol was able to take a farm from a family that had held it for 119 years. The crash hit British rural lending with particular ferocity, and not through the channels you might expect. It wasn't the big high street banks that drove it. It was the mid-size regional agricultural lenders, the ones that actually understood farm income cycles, that had been extending credit to families like the Calloways for generations, that pulled their lines fastest when the losses came. They needed to clean their balance sheets. Farm debt was illiquid, slow to resolve, complicated by planning laws and agricultural tenancy provisions. When the pressure came, agricultural loans were among the first things sold. Robert had borrowed £220,000 against Harlow's Bottom in 2006. The reason was not extravagance. The main cattle barn, which his grandfather had built in 1958 from corrugated iron and Douglas fir, had developed a roof failure so serious that the structural engineer his insurance company sent called it a liability rather than an asset. The replacement cost was significant. Simultaneously, revised Environment Agency regulations on agricultural waste management required a new slurry handling system, and the penalty for non-compliance was loss of operating license. Robert had no choice. He borrowed the money, had the barn rebuilt, had the system installed, and began meeting monthly repayments of £1,240, which was manageable at the cattle prices of 2006 and 2007. In the first quarter of 2009, Devon cattle prices dropped 17%. In the same quarter, the Trevithick family's arable operation, itself under financial pressure, deferred their seasonal rent payment. Robert missed 2 consecutive loan installments. That was all it took. Gerald Ashworth ran a company called Ashworth Land Recovery Partners, based in Bristol, which was precisely what its name suggested and nothing more. When agricultural borrowers defaulted, Ashworth's firm purchased the debt from the distressed lender at a discount, typically between 40% and 60% of face value. and then moved to enforce against the security, which was the land. It was a legal business. It was a systematic one. Between 2008 and 2012, Ashworth Land Recovery Partners acquired 14 farms across Somerset, Wiltshire, and Devon through this mechanism. 14 rows on a spreadsheet, 14 enforcement actions, 14 families who had built something and then watched someone in a pinstripe suit drive up and take it. Gerald Ashworth was not cruel in the way that simple stories require their antagonists to be cruel. He was something more banal, efficient. He had built a machine for identifying distressed agricultural debt, purchasing it cheaply, and converting it into land value. The machine worked. He was good at running it. And in the early months of 2009, Robert Calloway's farm appeared on the spreadsheet. Here is the thing I haven't told you yet, and this is the question I want to hold open for a moment because it matters more than almost anything else in this story. Why was Ashworth interested specifically in Harlow's bottom? He had 14 farms across 3 counties. Some were larger, some were more accessible. Some had better buildings. Why did his company pursue this particular 43 acres with such uncommon speed? I'll get to that. But first, I need to take you forward to a Tuesday morning in April of 2009, because that is when everything became visible. Ashworth came to the farm just after 9 in the morning. He drove a black Range Rover Discovery with Bristol plates. He wore a pinstripe suit, navy blue, double-vented, the kind of suit that costs more than 3 months of Robert's Trevithick lease income, and a gold watch on his left wrist that caught the low Devon light as he climbed out of the car. With him were Colin Marsh, a solicitor who carried a dark leather briefcase and had the careful blankness of a man paid never to look surprised, and a land agent named Stephen Price who carried a clipboard and a measuring wheel and who began walking the boundary the moment he arrived, as if the social dimension of what was happening was simply not his department. 14 people had gathered at the edges of the field by the time Ashworth arrived. Word in a Devon village travels the way it always has, through hedgerow and phone call and the quiet network of people who have been watching out for each other's families for 2 centuries. Dennis Wren was there, who farmed the adjacent land and had been Robert's neighbor for 30 years. A woman named Esther Pock was there, who had grown up on the lane and whose grandmother had once lent Jack Calloway a bull for 2 seasons with no paperwork, because paperwork between neighbors seemed excessive. 2 younger men from the village were there, whose names I won't use because they're still living, who stood at the far hedge with their arms folded and said nothing. Robert stood in the center of the field. The turned clay was dark brown and gave slightly underfoot, and the air smelled of diesel from Price's Land Rover, and beneath that, the particular green cold smell of Devon farmland in early April, damp and mineral and faintly sweet. Robert's arms were crossed. He had already read the enforcement notice. He knew what was coming. What Ashworth didn't know, what none of the people who had driven from Bristol that morning knew, was what Robert had been doing the previous afternoon. He had driven home from his solicitor's office in Kingsbridge after his second appointment in 3 days, gone upstairs to the back bedroom, opened the bottom drawer of an old metal filing cabinet that had belonged to his father Raymond, and spent 40 minutes going through a collection of documents in brown manila envelopes that had been accumulating in that drawer since at least the 1960s. Some of the envelopes were soft at the edges, the paper having absorbed decades of cold Devon air until it had the texture of old cloth. Robert had not opened most of them in years. He knew roughly what they contained. Farm records, old insurance certificates, correspondence about a boundary dispute in 1971 that had long since been resolved. He had been looking for something specific, something his father had mentioned once when Robert was perhaps 22. A passing comment about an old deed, and the old deed had a clause in it that Raymond had called peculiar, worth knowing about, probably never important. Robert found it in the 3rd envelope. He read it twice, standing under the bare 60-watt bulb of the back bedroom. Then he sat down on the edge of the bed and read it a 3rd time. Then he drove to Kingsbridge and made 2 phone calls from a payphone, because he didn't entirely trust his mobile that week. Now Ashworth walked across the clay toward him, his polished black shoes leaving distinct impressions with each step, and he pointed at the property boundary stone. He was already smiling. It was the particular smile of a man who has had this conversation 14 times and knows how it ends. "That stone," Ashworth said, "is now the boundary of my property, everything inside it. I'm giving you 60 days to vacate." Robert looked at him for a moment. "You might want to read the 1890 deed before you make that particular claim," he said. Ashworth laughed. It was a full, loud laugh, the kind that carries. The 14 people at the edges of the field heard it. Several of them would remember it later with a very specific private satisfaction. "The deed conveys the freehold," Marsh said without looking up from his briefcase. "Surface and subsurface. Standard conveyance language." Robert said nothing. Here is where I need to stop and explain something, because the reason that stone mattered, the reason Aldous Vickers' 7 lines of careful Victorian legalese from November 1890 mattered, had nothing to do with coal, nothing to do with iron ore, nothing that the men of 1890 could have anticipated. It had to do with something the science of 1890 could not have measured, something that no one in Devon was seriously thinking about until the early part of the 21st century. Let me explain what lies under clay-heavy farmland in the South Hams district of Devon. The geology of South Devon is a complex patchwork of Devonian-era formations, the result of sedimentary and tectonic processes laid down between 350 and 420 million years ago. The dominant rock types are slate, sandstone, and various limestone formations that outcrop intermittently across the region. For most purposes, most of the history of Devon in fact, the mineral content of these formations was considered commercially irrelevant. The county's mining tradition centered on Cornwall to the west. Tin, copper, china clay. South Devon had never been extraction country. But beginning in the late 1990s and accelerating through the early 2000s, 3 developments changed that calculation simultaneously. The first was the widespread commercial adoption of ground-penetrating seismic survey technology. Instruments that use controlled acoustic pulses transmitted into the earth and measure the return signals to construct detailed cross-sectional maps of subsurface geology. The physics are the same as an ultrasound scan. Send a wave in, measure how it bounces back from surfaces at different densities. But by the late 1990s, the processing power available to interpret those returns had increased to the point where you could map individual rock strata at depths of 50 to 300 meters with horizontal resolution of less than 2 meters. In 1890, you might have known vaguely that there was limestone under your field. By 2003, you could tell a prospective buyer exactly how thick it was, exactly where it began and ended, and exactly how pure it was likely to be based on acoustic density signatures. The second development was a change in the industrial chemistry of calcium carbonate. Calcium carbonate, the mineral compound that constitutes limestone, has dozens of industrial applications. Cement manufacture, agricultural lime for neutralizing acid soils, construction aggregate, whitening agent in paper and plastics production. These uses had been known for centuries, but in the early 2000s, the food and pharmaceutical industries began competing seriously for a specific grade of ultra-pure calcium carbonate powder, 94% purity or above, as a processing agent, a calcium supplement carrier, and a tablet coating medium. The dietary supplement industry alone was expanding at 11% per year at that point, and it needed calcium carbonate at pharmaceutical grade that existing European supplies struggled to meet. The third development was a geological reassessment of a particular limestone band running under the South Hams district of Devon. Geologists had mapped its existence since the 1950s, but its commercial value had been considered marginal because earlier survey technology could not determine its purity grade with sufficient confidence. A more detailed survey, completed in 2001 by the British Geological Survey, revised that assessment sharply upward. The formation, known in local geological literature as the Kingsbridge bed, turned out to be an unusually pure deposit of high calcium limestone, with purity levels in the 95 to 97% range, well above the pharmaceutical industry threshold. It ran roughly 22 kilometers through the South Hams at depth between 40 and 90 meters, which placed it beyond simple quarrying but well within the range of rotary drill extraction. The Kingsbridge bed ran directly beneath 43 acres of farmland in the parish of Harlow. You already know whose land that was. A Bristol-based mineral exploration company called Meridian Rock Partners had commissioned a detailed seismic survey of the area in 2007. The survey, which cost £114,000 and was conducted over 3 weeks in late autumn using a mobile vibro-Sears truck that several local residents described as making a sound like a slow, continuous underground heartbeat, confirmed what the BGS survey had suggested. The extractable deposit beneath the Calloway land was estimated at approximately 2.3 million tons, with commercial value at 2009 market prices of between £41 and £63 per ton, depending on processing grade. You do the arithmetic. The lower estimate gives you £94 million. The upper estimate gives you £145 million. Sitting under a farm being enforced against for a loan of £220,000. And here is the sentence I want you to sit with. Meridian Rock Partners had made contact with Ashworth Land Recovery Partners in the early months of 2009, before the enforcement action against Robert Calloway began. A letter subsequently obtained through legal disclosure proceedings, dated February the 9th, 2009. From Meridian's chief executive to Gerald Ashworth, personally, discussed the survey findings and the potential commercial arrangement that would follow if the surface ownership could be secured. The letter used the phrase surface acquisition with a specificity that indicated Ashworth understood very well what he was acquiring and why and what the ground below it was worth. He had known before he sent the enforcement notice, before he drove to Devon in his pinstripe suit. He had known. Robert Calloway had not known about the limestone. Not until the phone calls he made from the Kingsbridge payphone after finding the 1890 deed. The first call was to a woman named Patricia Holt, a property law specialist at a Totnes firm who had spent 15 years in mineral rights litigation before moving to Devon for what she had planned to be a quieter life. The second call was to a contact at the British Geological Survey, who confirmed in 15 minutes what the Meridian survey had mapped. When Robert met Patricia Holt the following morning, she read the 1890 deed for 17 minutes without speaking. Then she looked up. "Don't mention the clause to Ashworth," she said. "Don't mention it to Marsh. Let them take the surface. Say nothing about the subsurface." Robert looked at her steadily. "Why?" "Because the surface isn't what matters," she said. "And because if they know you know, they'll look for another route. Right now, they think this is a straightforward enforcement. Let them keep thinking that. There is a particular quality of stillness in a person who has been told they hold a card the other side doesn't know about, when the other side controls the table. Robert Calloway had that quality in the field that April morning, standing with his arms crossed while Ashworth laughed and Marsh spoke about standard conveyance language and Price's measuring wheel clicked around the perimeter. He said what needed to be said and no more. He showed nothing. The enforcement proceeded. Robert moved his 60 Hereford cattle to Dennis Wren's farm in Loddiswell, which Wren offered without being asked twice, which is how things work in that part of Devon when they work the way they're supposed to. Robert packed the farmhouse in careful stages over 3 weeks, putting his personal effects into a hired transit van and his farm equipment into a rented storage unit 8 miles away. On the last morning, he walked the perimeter of the 43 acres. Once, slowly. He didn't look back when he drove out. He had by that point already signed a mineral rights access agreement with Meridian Rock Partners. The agreement gave Meridian the right to drill and extract from the Kingsbridge bed beneath Harlow's bottom in exchange for an upfront access payment of £620,000 and a royalty of £4.70 per extracted ton, payable quarterly, secured against the subsurface mineral rights that remained, as Aldous Vickers had ensured in November 1890, legally and irrevocably his. Patricia Holt had spent 4 days satisfying herself that the clause was watertight before she let Robert sign anything. She had read the 1890 deed alongside the full chain of subsequent conveyances, 1898, 1931, 1947, 1983, 1994, and confirmed that not one of them had executed the separate, explicit instrument of conveyance that Vickers's clause required to transfer the mineral rights. Not because anyone had deliberately chosen to leave the mineral rights with the Calloway line, because no one had thought to check, because the clause was on page 3 of an 1890 deed and nobody involved in any of those subsequent transactions had read page 3 of an 1890 deed with the care that Aldous Vickers had written it. "It's clean," Holt told Robert. "The mineral rights never moved. They stayed with your line from 1890 to now. Every transfer moved the topsoil and the barn and the grazing rights and the boundary stone. None of them moved what's 40 meters below that boundary stone." Ashworth didn't find out for 11 weeks after taking possession. The letter came from Holt's firm in early September of 2009. It was 4 pages long, written in the measured language of someone who is entirely certain of their position and has no need for theatrical flourishes. It cited the 1890 deed, the relevant provisions of the Land Registration Act 2002, 3 judicial precedents in English property law, and, most significantly, the February 2009 letter from Meridian Rock Partners to Gerald Ashworth, which established that Ashworth had possessed knowledge of the subsurface mineral value before initiating the enforcement action. That last item transformed the case. A property dispute about a clause one side hadn't checked was one kind of legal matter. A property dispute in which the enforcing party had knowingly targeted land for its hidden subsurface value while using an agricultural debt default as the legal mechanism was something with considerably sharper edges. Marsh called Ashworth at 7:40 that evening. There was, by Marsh's later account, a silence on the line that lasted somewhere between 10 and 15 seconds after Marsh explained what the letter said. "How?" Ashworth said finally. "A clause. From 1890. We didn't. The title register doesn't show it. Because mineral rights created before the Land Registration Act 2002 are not required to appear in the title register," Holt would explain in her formal witness statement. "They survive as overriding interests under Schedule 3 of the Act. Any competent purchaser or any competent solicitor acting for a purchaser who had conducted proper pre-registration inquiries would have encountered the 1890 deed. The obligation to conduct those inquiries rested with the purchaser. It was not discharged." Justice Cavendish Brown, sitting in the Exeter Court in the spring of 2011, spent 11 minutes in her oral judgment distinguishing between a failure to conduct due diligence and a deliberate decision not to conduct it. She did not conclude the latter, but she did note, in language that a number of legal commentators later described as pointed, that the timing of Meridian's February letter relative to the enforcement notice gave rise to questions about the nature of the interest being pursued, and that these questions were material to the assessment of damages. The case settled out of court in March 2011 after 22 months of proceedings. The terms were confidential, but 3 matters became part of the public record. The surface freehold of the 43 acres was returned to Robert Calloway for a nominal consideration of £1, paid on a Thursday morning in a solicitor's office in Exeter. Ashworth Land Recovery Partners paid an undisclosed sum in damages, reported by regional legal journalists as somewhere between £2 and £4 million based on court documents they had been able to review. And Gerald Ashworth resigned as managing director of his company in April 2011. The company itself was wound up 6 months after that, its remaining portfolio of acquired farm properties liquidated in an orderly process overseen by administrators. The drilling rig arrived at Harlow's Bottom in October 2011. It was a Bort Longyear LM Series rotary drill, 41 feet of yellow-painted steel that people in the surrounding half-mile could hear and feel simultaneously. A deep, grinding percussion that those who lived closest described, consistently and without coordinating their descriptions, as feeling like a second heartbeat beneath the floorboards. The drill bit went into the clay at 2 meters per minute through the upper strata and slowed to 40 centimeters per minute as it entered the transitional zone where clay gave way to the first fractured limestone. At 63 meters, the core sample came up pale gray, dense and clean. The meridian geologist on site, a woman named Dr. Sarah Penhaligon, who had been with the company since the original 2007 survey, ran her thumb along the face of the core cylinder and said nothing for a moment. Then she said, "That's it." It was. Purity analysis of the first core sample returned 96.7% calcium carbonate. Above pharmaceutical grade, above the threshold that triggered the highest price band in Meridian's extraction contracts with the food industry. Extraction commenced in the spring of 2012 at a rate of 40,000 tons per year, using a combination of directional drilling and controlled subsurface fracturing that left the surface of Harlow's Bottom entirely intact above it. The field above the extraction zone continued to carry cattle. The grass grew. The boundary stone stayed where it had always been. The royalty payments began arriving for Robert Calloway in April 2012 at the rate of £4.70 per tonne, paid quarterly. By the end of that first year, he had received £238,000 in royalties, sitting alongside the £620,000 upfront access payment from 2009. He paid off the original agricultural loan in full. He bought back his 60 Herefords from Dennis Wren in Loddiswell, paying exactly what Wren had paid for them, because Wren had made a point of keeping separate accounting for them precisely against this possibility. He moved back into the farmhouse. He planted a line of 31 field maples along the western boundary, one for each year he had been farming. And on the morning the last one went in, he drove his tractor a slow circuit of the 43 acres. Not to inspect anything, just to feel the ground under the wheels. Now, there is a question I've been carrying through this whole story, and I want to put it to you directly. Have you ever inherited something, an object, a habit, a document, a way of doing things, that you treated as ordinary or even burdensome without understanding what it actually was? Think about that for a moment, because that is the question at the center of everything that happened at Harlow's Bottom. Thomas Calloway paid £82 for a field in November 1890, and a careful solicitor gave him something he didn't ask for. For 119 years, that thing sat in an envelope in a filing cabinet, passed from generation to generation with everything else: the land, the debt, the cattle, the particular knowledge of when the East Corner floods. Raymond Calloway mentioned it once to his son, called it peculiar, said it was probably never important. Probably never important. And then one afternoon in 2009, in a back bedroom under a 60-watt bulb, a 53-year-old farmer with cracked hands opened the third envelope and found that it was the most important thing his family owned. The only interview Robert Calloway gave at any length was published in the Western Morning News in November 2013. The journalist asked him what he had been thinking about standing in that field in April 2009 while Gerald Ashworth laughed. Robert was quiet for a moment. Then he said, "I wasn't thinking about the limestone. I was thinking about my great-great-grandfather buying that land for £82 and whether he thought about what he was leaving behind him. That is not the answer a man gives if he has been thinking about victory. It is the answer a man gives if he has been thinking about continuity." Let me tell you what happened to Gerald Ashworth, because this story doesn't end the way you might expect it to. He gave one public statement after the settlement through his solicitors. 4 sentences. The last of them read, "I accept that our firm failed in its due diligence obligations and that the consequences fell unjustly on Mr. Calloway and his family." That sentence was not legally required. The settlement was confidential, the damages were paid, the admission wasn't necessary to close the matter. Someone chose to include it. The most likely person who made that choice is the man who had to live with what had happened. Ashworth spent 2 years after the dissolution of his company in quiet consultancy work. In 2014, he began lecturing part-time at the University of the West of England on land transaction law. He has taught the same module every year since. It covers pre-registration encumbrances, overriding interests, Schedule 3 of the Land Registration Act 2002, and the professional obligations of solicitors acting for purchasers of rural property. The case study at the center of the module is drawn from a 2011 settlement involving 43 acres in the South Hams district of Devon. He doesn't name the parties. He has told colleagues he doesn't need to. His students leave that lecture knowing what a careful man's habits are worth. They learn that what appears in the title register is not the complete picture of what you're buying. They learn that the most consequential documents are sometimes the ones buried on page 3 of a deed written in a farmhouse kitchen in November of 1890 by a solicitor whose name you've never heard. Aldous Vickers taught them that 136 years later, through a chain of consequences he could not have imagined and a field he never saw. The drilling operation at Harlow's Bottom continues. The extraction rate has settled at 38,000 tons per year as the Kingsbridge bed's geometry narrows slightly at depth in the section beneath the Calloway land. Geological modeling suggests 60 to 80 years of commercially viable material remains at that rate, which means the royalty agreement Robert signed in the summer of 2009 will almost certainly outlive him. The mineral rights will pass, as Aldous Vickers intended, to his lineal descendants in whatever world they inhabit. Patricia Holt wrote the succession provisions into the current agreement herself. Robert's daughter, Clara, now manages the farm alongside her father. She is 29. She has a degree in agricultural science from Exeter and the same habit her father has of looking at the ground she's standing on. More as inheritance than necessity, though she would probably not put it that way. She is the one who had the property boundary stone cleaned and reset. The brambles around its base were cleared. You can read the lettering cleanly now in the November light. Property boundary, 1898. She didn't add anything to it. She said, when asked, that it didn't need anything added. The stone weighs 14 pounds. It has been in the same spot for 127 years. Gerald Ashworth, in a pinstripe suit, pointed at it and laughed. A solicitor named Aldous Vickers, working in bad light in 1890, wrote 7 lines that no one would need for 119 years, and that would then matter enormously. What gets passed down is rarely what we think we're passing down. Sometimes it's land. Sometimes it's cattle. Sometimes it's a name or a habit or the particular way a person looks at the ground they're standing on. And sometimes it's a solicitor's careful instinct, 7 lines in a brown envelope in a filing cabinet drawer, waiting patiently for the day that the person who needed it most would finally open the 3rd envelope. That story is still unfolding. The drill is still running. The quarterly payments still arrive. The field maples Robert planted along the western boundary are now 14 years old, tall enough to cast a real shadow in the late afternoon, their roots going down into the same clay-heavy Devon soil that sits above the Kingsbridge bed, above the pale grey limestone that nobody wanted, that nobody thought was worth anything, that has been down there for 350 million years, waiting. Stories like this one, about the things we inherit without understanding, about the documents we almost throw away, about what careful people leave behind them, don't get told enough. If this channel matters to you, leave a comment and tell me. What's the thing in your family that everyone dismissed as worthless, that turned out to be something worth holding on to? I read everyone.